Hi, in today's session, we will talk about nature and types of marriages as per the Hindu Marriage Act 1955. As per the old Hindu law, marriage ceremony is the last of the 10 sacraments of the purifying ceremonies. According to the ancient Hindu law, marriage tie is a tie which can never be broken, and it is a relation established from birth to birth. It is believed that the husband receives his wife from the gods and must always support his wife, of course, if she is faithful. Hindu marriage is unlike Christian or Muslim marriage, where marriage is treated like a contract and can be broken by mere offer and acceptance, which are typically the two key essentials of a contract. Hindu marriage is a sacrament of holy union for the performance of religious duties. Divorce, for example, was unknown to the old textual Hindu law of marriage. It got introduced only in Hindu Marriage Act 1955. Hindu Marriage Act 1955, which is the present law in place, concludes that a Hindu marriage is not merely or necessarily a sacrament uh, or, or necessarily a sacrament. It is a union of one man with one woman to the exclusion of all others, satisfied by a solemnization of the customary rites and ceremonies of either party, essential for a marriage, and directly it exists, creates a relation and status not imposed by or defined by contract, but it is defined by law. In addition, Section 13 gives to both husband and wife the right to petition to court of divorce on anyone on the grounds mentioned in in this particular section, which is section 13. Now let's look at the different types of marriages as per the Hindu Marriage Act. There are three categories or three broad categories in which the types of Hindu marriages can be defined. One is we call it as a valid marriage, which means the conditions for a valid Hindu marriage. What are those specific conditions? We'll look into it. Then second one is void marriages. I mean, when we can call a marriage to be a void, as per section 11, and voidable marriage, which means as per section 12. What are those specific conditions when we can call a marriage to be a voidable marriage? So valid, void, and voidable. As far as the valid marriage is concerned, for a marriage to be considered to be valid in the eyes of code of law, following conditions must be fulfilled or taken care of. First is monogamy. It is defined in Section 5I clause. This provision prohibits bigamy. The marriage should be monogamous. Under the Hindu law, a person can validly marry if he or she is either unmarried or divorced or a widow or a widower. If at the time of the performance of the marriage rites and ceremonies, either party has a spouse living and the earlier marriage had not already been set aside, the later marriage is void. A bigamous marriage is null and void and is made punishable as well as per the IPC sections. The second condition is sanity. The person should be sane. Section 5, Clause 2 defines the parties to the marriage should not suffer from unsoundness of mind, mental disorder, or insanity. In all the cases given in Section 5, Clause 2, the party is regarded as not having the mental capacity to solemnize the marriage. So, if a party who solemnized the marriage is suffering from unsoundness of mind, mental disorder, or insanity, the marriage is voidable at the opinion of the other party. The third condition of a marriage being valid is the age. Section 5, Clause 3 defines that at the time of marriage, the bridegroom has completed the age of 21 years and the bride the age of 18 years. If the marriage is solemnized in contravention of this condition, it is neither void nor voidable. Beyond prohibited degrees, Section 5, Clause 4 defines that the parties to the marriage should not come within the degrees of prohibited relationships. Two persons are said to be within the degrees of prohibited relationships if one is linear ascendant to the other, or if one was the wife or husband of linear ascendant or descendant of the other, or if one was the wife of the brother or of the father or mother, brother, or of the grandfathers or grandmother, brothers of the others. The fourth is if the two are brother and sister, uncle and niece, aunt and nephew, or children of brother and sister of or two brothers or of two sisters. A marriage between two persons who come within the degrees of prohibited relationship shall be void. However, if there is a valid custom or usage governing both the parties, allow they can marry even though they come within the degree of the prohibited relationships. The fifth condition is beyond Sapinda relationship, which is defined in section 5, clause 5. The parties to the marriage should not be treated to each other as Sapindas. A marriage between Sapindas is void. So these are the five conditions to be met before we can call a marriage to be a valid marriage. Let's look at void marriage. Void marriage is mostly the other way around of the valid marriage. It is defined in section 11, and it says a marriage will be considered as void if it is bigamy, which is opposite of monogamy, if it is done in the prohibited degrees of relationship, which is what we spoke about in the valid marriage as well, if it is being done in Sapinda relationship, which is what the condition was in the valid marriage, that it should be beyond Sapinda relationship. The third category of marriages, or we can call a marriage to be avoidable marriage, is defined in section 12. Avoidable marriage, also called as avoidable marriage, is a marriage which can be cancelled at the option of one of the parties. The marriage is valid but is subject to cancellation if contested in the court by one of the parties to the marriage. And normally, these are the four scenarios in which one of the parties can go to the court and declare the marriage as avoidable marriage. The first is impotency, which is as per section 12, clause 1a, which says if either spouse was physically incapable of entering the marriage at the time of the marriage, usually because of the lack of ability to have sexual intercourse, and if this inability appears incurable or if the spouse refuses to take any action to cure the inability, there are grounds for an annulment. The inability must continue and must exist at the time of filing a suit or as the suit is continuing. Insanity, unsoundness of mind, as per section 12, 1b clause, if the court finds that either spouse did not have the ability to understand the nature of the marriage contract or the responsibilities and the duties of the marriage contract, then there may be grounds for an annulment. However, if the spouse who did not have the ability to understand the contract gains the capacity to understand it and freely lives with the other spouse, then this ground does not apply. The third one is consent obtained by force or fraud, which is defined in section 12(1)(c). If the consent to the marriage contract was obtained either by fraud or by force, then there are grounds for an annulment. The person who has been threatened or deceived about the marriage contract continues to live with the spouse after the discovery of the fraud or the deception, or after being forced into the marriage, it is possible that this ground may not apply. The last is pregnancy of the respondent. Um Section 1D defines that the respondent was at the time of marriage pregnant by some other person other than the petitioner. Then that is one possible cause of a marriage being declared as voidable or void. So these are the nature and types of marriage under the Hindu law, Marriage Act 1955. That's all we have to cover in today's session. I mean, if you have any questions or queries, you can visit www.juristknowledge.com, or you can download this presentation from www.juristknowledge.com as well. Thank you.